There is a chair in a photograph taken in 1923. It sits in the center of a bare room, linoleum floor, whitewashed wall, a single window with wire mesh pressed into the glass. The chair is wooden, slat-backed, the kind of chair you'd find in any American kitchen of that era, unremarkable in every dimension except one. Strapped to its legs at ankle height are leather cuffs, worn smooth, dark with age and friction. The photograph comes from the administrative archive of the Columbus State Hospital in Ohio. It was filed under the heading, Therapeutic Furniture, Ward C, Female. Therapeutic. That word, that specific, deliberate word choice in a document signed by a licensed physician, countersigned by a state administrator, filed in triplicate, and stored for 60 years before a graduate student in 1987 accidentally pulled the wrong box from a shelf and found it staring back at her. She published a single footnote about it. The footnote was not included in subsequent editions of the textbook. I want to talk to you today about that chair, about the system that produced it, named it, filed it, and then with extraordinary efficiency made it very difficult to find. I want to talk about what happens when a government decides that certain categories of human beings are inconvenient, not dangerous necessarily, not criminal, just inconvenient, expensive, dissonant. And I want to talk about the paperwork. Because unlike fires, unlike wars, unlike the slow erosion of oral tradition, the erasure of the institutionalized poor in 19th and 20th century America left a paper trail. Fragments of it survive. And when you read those fragments carefully, and you lay them against each other, and you do the mathematics that the original administrators clearly hoped you wouldn't bother to do, a pattern emerges. Not a conspiracy. I want to be precise about that distinction. A conspiracy requires secrecy and coordination among actors who know they are doing something wrong. What I'm going to describe to you today is something arguably more disturbing. A system that operated openly, that published its logic in government reports and medical journals and legislative proceedings, that was reviewed and approved and expanded by successive administrations across more than a century, and that has nonetheless been almost entirely removed from the standard American historical narrative. The chair in the photograph was not hidden, it was filed. That's the difference, and that difference matters enormously. The story we are generally taught about the American psychiatric institution, when we are taught it at all, goes something like this. In the early 19th century, the treatment of the mentally ill was chaotic, cruel, and unregulated. Disturbed individuals were housed in poorhouses alongside paupers and criminals, chained in cellars, displayed in institutions like Bedlam in London as curiosities for paying visitors. It was a dark time, characterized by ignorance and a lack of scientific understanding. Then came reform. Dorothea Dix, a Massachusetts schoolteacher, conducted a survey of Massachusetts jails and almshouses in 1841 and was horrified by what she found: people with mental illness kept in cages, in closets, in stalls. She launched a campaign before the Massachusetts legislature, then before Congress, advocating for the construction of dedicated state hospitals for the mentally ill. Her moral crusade succeeded. By the 1860s, state asylums were being constructed across the country, staffed by physicians, built according to a philosophy called moral treatment, the idea that a calm, structured, humane environment could itself be curative. It was progress, scientific, humanitarian, institutional progress. The asylums grew. They became self-sufficient communities, farms, bakeries, laundries, where patients were treated with dignity and purpose. There were problems, of course, as the population grew and funding failed to keep pace. Overcrowding emerged. The idealism of the founding generation gave way to custodialism. And then in the 1960s and 70s came deinstitutionalization, the recognition that these enormous facilities had become warehouses for human beings, that psychiatric medication offered an alternative to confinement, and that people deserved to live in communities. The arc bends toward justice, the system corrected itself. That is the standard narrative, and it is not entirely false. Dix existed, the hospitals were built, deinstitutionalization happened. These are documented facts. What the standard narrative does is something more subtle. It selects. It emphasizes the reformers and elides the mechanisms. It names Dorothea Dix and declines to name the legal architecture that gave the system its teeth. It describes conditions as products of overcrowding and underfunding, rather than examining what precisely the law permitted and enabled. and in some cases required. Let me tell you what the law actually said. In 1845, the United States Supreme Court decided the case of Cookson v. Pennington. Actually, let me back up. Before we get to the federal level, we need to understand the mechanism at the state level, because that is where the real architecture was built. The Commonwealth of Massachusetts passed, in 1836, what was called the Act for the Relief of Lunatics, and I want you to notice that framing. Relief. The Act established procedures for committing individuals to state institutions. The standard of commitment was not criminal conviction. It was not demonstrated harm to others. It was a certificate signed by 2 physicians, later reduced in several states to one attesting that the individual was, in the language of the Act, a person of unsound mind and a proper subject for treatment. A proper subject for treatment. No trial, no jury, no appeal mechanism in the original statute. 2 signatures or 1, and a person could be transporting to a state facility and held indefinitely. By 1870, 33 of the 37 states in the Union had enacted similar commitment statutes. The language varied. The threshold did not vary much. In many states, the statutory language included categories so broad as to be, by any reasonable reading, functionally unlimited. The Iowa Code of 1873 permitted commitment for intemperance, excessive self-abuse, epilepsy, and hereditary predisposition. The 1874 revision of the Illinois Commitment Statute included the category of mental exhaustion from overwork. Mental exhaustion from overwork. I am reading from the archived text of the Illinois Revised Statutes, 1874, page 487, currently held in the Illinois State Archives and accessible through the Newberry Library in Chicago. This is not a fringe source. This is the statutory law of the state of Illinois, in force, enforceable by sheriff's deputies and county courts. Now, here is where the mathematics becomes important. The first federal census to include enumeration of asylum populations was 1850. In that year, the total recorded population of American state and county asylums was approximately 4,700 individuals. By 1880, the next census in which detailed institutional data was collected, that number was 91,997. By 1903, the figure had reached 150,000. By 1940, it exceeded 400,000. These are census figures. They are available through the U.S. Census Bureau's historical records, and through the work of historian David Healy and sociologist Andrew Scull, whose research I am drawing on directly. 400,000 people, committed without criminal trial, held without fixed sentence, managed under statutes that required no higher burden of proof than a single physician's signature. The standard narrative calls this unfortunate overcrowding. I call it a mathematical pattern that demands explanation. Who are these people? Let us look at the intake records. Not all intake records survive. This is itself a significant fact, which I will return to. But a substantial body of records does survive, concentrated primarily in state archives and in the work of researchers who, beginning in the 1970s, began the painstaking process of reading individual case files. Ellen Dwyer's study of the Willard and Utica asylums in New York, published in 1987, examined thousands of case files from the period 1870 to 1910. Her findings were not presented as sensational. They were presented as a scholarly monograph published by Rutgers University Press, which is perhaps why they remain substantially outside the popular historical consciousness. What she found: women constituted a dramatically disproportionate share of committed individuals in the institutions she studied. The recorded reasons for commitment in female cases included, with significant frequency, domestic trouble, husband's exposure to alcohol, grief following childbirth, religious excitement, novel reading, and I want you to hold this one, masturbation. That last category appeared in both male and female records, across dozens of institutions, well into the 1910s. Not as a curiosity, as a clinical diagnosis, as a legal basis for indefinite commitment. In the records of the Danvers State Hospital in Massachusetts, now a luxury apartment complex called Avalon Danvers, which is its own kind of commentary, the stated reason for admission, in case after case from the 1880s and 1890s, is rendered in single words or brief phrases: excitement, melancholy, moral insanity, hereditary taint. Hereditary taint, not a diagnosed condition. a presumption based on family history, which is to say, a presumption based on poverty, on immigration, on the wrong kind of grandfather. Now let me give you a number that the standard narrative almost never discusses. Edward Shorter, in his 1997 History of Psychiatry, drawing on census and institutional data, estimated that at the peak of institutionalization in the United States, roughly 1940 to 1955, the per capita rate of psychiatric confinement in the United States was among the highest of any industrialized nation on Earth, higher than Great Britain, higher than France. Comparable, in raw proportional terms, to the Soviet Union's use of psychiatric facilities in the same period, a practice that Western governments at the time condemned as a fundamental violation of human rights. I am not constructing a moral equivalence between democratic and authoritarian systems. I am observing a numerical fact: the rate of confinement, the breadth of the legal standards, the absence of adversarial legal process. These are structural features, not incidental failures, and they are documented in the institutional records of American state governments. Here is the question those numbers force upon us: what problem exactly was being solved at this scale? To understand what was being erased, we need to understand something about property. When an individual was committed to a state asylum in the 19th century, what happened to their legal identity? What happened to their capacity to own property, to sign contracts, to vote, to initiate legal proceedings? The answer is documented in the statutes, and it is stark. In the majority of states, commitment to a lunatic asylum, again, on the signature of one or two physicians, with no judicial trial, triggered automatic legal incompetency. The committed individual lost the right to control their property. A guardian, typically appointed by the county court, typically a male relative or, in the absence of family, a court-appointed administrator, assumed legal control of all assets. In states with large immigrant populations, particularly in the Midwest and Northeast, this mechanism had a specific demographic application that is recorded in the work of historians Gerald Grob and David Rothman. Newly arrived immigrants, often without English language skills, unfamiliar with American legal process, sometimes holding property in the form of cash savings or deeds to small plots of land, were committed at substantially higher rates than native-born Americans. The reasons recorded in their case files were, in a significant proportion of cases, linguistic: incoherence, inability to communicate, confused speech. Inability to communicate as a basis for indefinite commitment, and legal incompetency. The property, once the individual was committed, was administered by the appointed guardian. If the individual died in the institution, and many did, mortality rates in state asylums were, in multiple documented periods, catastrophically high. The property passed through the guardianship system, often to parties who were neither family members nor disinterested administrators. I want to be precise. I am not claiming that every commitment was a property theft. The records do not support that sweeping claim. What the records do support is that the legal framework permitted that outcome without meaningful safeguard, that it happened with documented frequency, and that the individuals most vulnerable to it were the poor, the foreign-born, the widowed, and women in conflict with their husbands or families. These are not marginal cases. The case files are in the state archives. They are in the Willard asylum records at the New York State Archives in Albany. They are in the Traverse City State Hospital records in Michigan. They are in the Oregon State Hospital records, the same facility depicted in One Flew Over the Cuckoo's Nest, which is a fictional work, but which was written by Ken Kesey after he worked as a night aide in a veteran's psychiatric ward and witnessed the non-fictional version of its events. Some records are not in the archives. The 1890 federal census included, for the first time, a comprehensive effort to enumerate asylum populations by state, by diagnosis category, by nativity, and by length of confinement. This data would have allowed, for the first time, a systematic national analysis of who was being committed, for what reasons, and for how long. The 1890 census records were destroyed in a fire in 1921. The cause of the fire was never definitively determined. This is documented. The fire is documented. The loss of approximately 25% of the 1890 census records, including a disproportionate share of the institutional population data, is documented. I am not speculating about the fire. I am noting what was lost in it, and I am noting that the loss made a specific category of historical analysis permanently more difficult. I observe a pattern, I do not assert a cause. But there is something else. Something that is not about fire, not about accident, not even about neglect. It is about the systematic management of institutional memory at the facility level. In 1955, a young architectural historian named Kenneth Baxter was commissioned by the state of New York to survey the existing structures of the Willard Psychiatric Center on Seneca Lake. His survey notes, unpublished, held in the collection of the New York State Museum, describe something that I find, even reading them in transcript form, genuinely strange. Beneath the main administrative building, Baxter documented a series of underground corridors connecting the original 1869 structure to several later additions. These corridors, he noted, had been sealed, physically blocked with poured concrete, at some point between 1920 and 1935. He could not enter them. He could only note their existence from the architectural drawings and from the evidence of the blocked doorways. He asked the facility administrator about the corridors. He recorded the response: storage, flooding, we sealed them off years ago. He noted in his survey, administrator unable to provide date of sealing or documentation of flooding event. The Willard facility was demolished beginning in 1995, following closure. During demolition, workers discovered what the corridors had contained. They contained, among other things, nearly 400 suitcases, patient suitcases, each one packed by the patient or by their family at the time of admission in the expectation that the stay would be temporary, each one tagged with a name. Many of them were never opened after the day they were packed. The suitcases are now in the collection of the New York State Museum. Some of them have been displayed in a traveling exhibition. The exhibition is called Lost Cases, Recovered Lives, and it is a genuinely moving piece of public history. I encourage you to seek it out. But I want you to notice what the suitcases represent at a structural level, beyond the obvious human pathos. They represent the physical evidence that a significant proportion of the people committed to Willard did not expect to be there long. They came with belongings. They came with the normal expectation of departure. And then they did not depart. And the suitcases went into the sealed corridors. And the corridors were filled with concrete. And the administrator told the architectural historian, flooding. The suitcases survived because they were sealed in a dry corridor. The flooding story does not account for their preservation. I observe the discrepancy, I note it, I move on to the pattern. The construction of American psychiatric institutions does not occur in a legislative vacuum. It occurs in a specific, compressed time period, alongside a cluster of other laws that are generally taught separately, but which share a common structural logic. Consider the chronology. The major expansion of state asylum construction occurs between 1860 and 1890. In that same 30-year window, the Homestead Act of 1862 opens federal land for settlement, but as detailed in the work of historian Kerry Lee Merritt, excludes formerly enslaved people through administrative mechanisms and distributes land through a process so bureaucratically demanding that by 1900, fewer than 16% of homestead claims had been successfully completed by poor or landless applicants. The National Banking Acts of 1863 and 1864 restructure American currency and credit in ways that systematically disadvantaged rural and small-scale borrowers. The Indian Appropriations Act of 1871 eliminates tribal treaty status and opens reservation land to administrative dissolution. These laws are taught in different chapters of different textbooks: land policy, banking reform, Indian affairs, psychiatric medicine. But they share a structural feature. They each create a legal mechanism that transfers resources, land, capital, legal standing, bodily autonomy, from one category of people to another, and they each do so through the medium of state and federal bureaucracy, creating paper records that are voluminous, technical, and functionally almost inaccessible to the people most affected by them. The person committed to an asylum on a physician's certificate did not read the Iowa Revised Statutes. The immigrant farmer who lost his homestead claim to a legal technicality did not have an attorney. The tribal nation whose treaty was voided by administrative reclassification did not have representation in the proceeding. The paperwork was real. The paperwork was thorough. The paperwork recorded the transaction in precise legal language. And the paperwork was filed in institutions staffed by people who understood it, produced it, and benefited from the system it documented. I am not describing a secret. I am describing the visible surface of a system that processed human beings through bureaucratic categories and produced outcomes that have been, with considerable efficiency, separated in the historical record from the mechanisms that generated them. The asylum sits in one chapter, the Land Act sits in another, the banking law sits in a third, and we read each one as a discrete policy response to a discrete social problem, rather than as components of a single administrative logic. That separation is not accidental. It is how the curriculum was designed. I can document that claim too, but it requires another episode. In 1963, President John F. Kennedy signed the Community Mental Health Act. It was one of his last pieces of domestic legislation. He was assassinated 6 weeks later. The act funded the construction of community mental health centers as an alternative to state hospitalization and is generally cited as the legislative origin of deinstitutionalization. The standard narrative treats deinstitutionalization as a liberation. Psychiatric medications, chlorpromazine, introduced in 1954, haloperidol 1958, lithium, approved in the US in 1970, made community living genuinely possible for many people who would previously have required institutional support. The civil rights framework of the 1960s provided the moral vocabulary to challenge involuntary commitment. Court decisions, most significantly, O'Connor v. Donaldson 1975, in which the Supreme Court held that a state cannot constitutionally confine a person against their will simply because they are mentally ill, without demonstrating dangerousness, changed the legal landscape. These were real changes. I want to be honest about that. But here is what the standard narrative of deinstitutionalization consistently omits. The community mental health centers that were supposed to replace the state hospitals were never adequately funded. The 1963 Act authorized construction. It did not guarantee operational funding. By 1980, when the Reagan administration consolidated and reduced the mental health block grant, the community center network was substantially incomplete. People were released from state hospitals into communities that had no infrastructure to support them. And here is the number that should be in every textbook and is in almost none of them. Between 1955 and 1994, the population of state psychiatric hospitals in the United States declined from approximately 560,000 to approximately 72,000. Nearly 500,000 people were released from institutional care over 4 decades. In that same period, the population of American prisons increased from approximately 185,000 to approximately 1,500,000. I am not asserting a direct one-to-one transfer. The demographics do not perfectly overlap. The timeline is not perfectly synchronized. Criminologists and sociologists debate the relationship and the mechanisms. But I am asking you to sit with that juxtaposition. 500,000 people removed from one institutional system, more than 1 million added to another. And in both cases, the people most represented in those numbers are poor, are disproportionately from communities of color, are disproportionately without access to legal representation, and are subject to administrative procedures that in the psychiatric case through commitment statutes, in the criminal case through mandatory minimums, plea bargaining rates, and pretrial detention, produce outcomes substantially disconnected from the adversarial legal process that American civics describes as the foundation of justice. The chair with the leather cuffs is filed under Therapeutic Furniture. The plea agreement signed in a hallway outside a courtroom by a defendant who has been in pretrial detention for 8 months and cannot afford bail, and whose public defender has a caseload of 400 clients. That document is filed under Justice Administered. The category name changes, the mechanism persists. The Danvers State Hospital, as I mentioned, is now the Avalon Danvers Luxury Apartment Complex. The original 1878 Kirkbride building, the Victorian Gothic centerpiece of the campus, designed according to Thomas Kirkbride's theory that beautiful, symmetrical architecture was itself therapeutic, was largely preserved in the conversion. It is, by most accounts, a striking building. The apartments are expensive. The marketing materials describe the building's history as a feature: original architectural details, historic character, unique provenance. They do not describe what the building was for. In 2009, during construction work on the Danvers conversion, workers excavating near one of the outbuildings uncovered a burial ground. More than 1,000 graves, most marked only with numbered metal stakes. Patients who died at Danvers, some after decades of institutionalization, and were buried on the grounds with no name marker, only a number corresponding to a case file. The case files, for most of these individuals, no longer exist. The construction was paused. A brief archaeological survey was conducted. The graves were documented. Construction then resumed. The burial ground is now beneath a parking structure. I have read the archaeological survey report. It is a thorough and professionally conducted document. It was filed with the Massachusetts Historical Commission. It notes the presence of the grave, their approximate dates, and the impossibility of identifying most of the deceased from surviving records. It is filed, it is accessible, it is not read. The Traverse City State Hospital in Michigan, opened in 1885, designed according to the same Kirkbride principles, is now a mixed-use development called The Village at Grand Traverse Commons. Restaurants, shops, residential units, a boutique hotel. It is genuinely beautiful. The architecture has been carefully restored. I have seen photographs. It looks like the kind of place you would want to spend a weekend. The marketing materials describe it as a vibrant community built on a foundation of history. They are not wrong, they are only incomplete about which history. There is a phenomenon in cognitive psychology called motivated forgetting, the documented tendency of individuals, and by extension institutions and cultures, to encode certain categories of memory less reliably than others. It is not lying. It is not conspiracy. It is the ordinary operation of a mind or a system that finds certain information more comfortable to retain than other information. The luxury apartments are more comfortable to inhabit than the numbered grave beneath the parking structure. The narrative of reform, Dorothea Dix' moral treatment, the arc bending toward justice, is more comfortable to teach than the commitment statistics, the property transfer mechanisms, the 1874 Illinois statute, the sealed corridors, the concrete. I am not asking you to be uncomfortable for its own sake. I am asking you to consider what it means that the most comprehensive records of the largest peacetime confinement in American history, more than 500,000 people, at its peak, are housed in archives that require institutional affiliation to access, that are not indexed in formats readable by search engines, that have been processed by a handful of academic specialists whose monographs are published by university presses and assigned in graduate seminars, and almost never reviewed in publications that anyone reads on a Saturday afternoon. The information is not hidden, it is filed. The question I want to leave you with is this. We understand in our standard historical vocabulary what it means to destroy evidence. A fire, a shredder, a bulldozer, we have language for that, we have a moral category for it, destruction of evidence, suppression, erasure. What is our moral vocabulary for evidence that is preserved in complete, professionally maintained archives, indexed and catalogued and technically accessible, and simply never assigned to the curriculum, never included in the textbook chapter, never mentioned in the museum exhibition that focuses on the architecture rather than the numbered grave? What do we call a system that keeps its own records and bets, correctly, that almost no one will read them? There is a chair in a photograph taken in 1923. It is in the archive. It has been in the archive for over 100 years. The leather cuffs are worn smooth. The archive is open to the public by appointment between 9 and 4, Monday through Friday. No one has gone to look at it. Or almost no one. The question is, why do we find it so easy not to?